Hello, everyone, and welcome to the AFTD educational webinar, FTD Care Planning with Essential Legal Documents. I'm Dina Chisholm, AFTD's Education Program Manager, and on behalf of everyone here, thank you for joining us today. A few housekeeping items before I introduce our guests. Please note our audience will be muted for the duration of the presentation. This helps to keep the background noises to a minimum so that everyone can hear the presenters clearly. If you have any technical issues, please write a message in the questions box and AFTD's Lauren Gaudier and Sharon Denny will address them with you. We are recording this presentation and will post it on AFTD's website and YouTube channel. Please share it with others as you think it may be interested. At this point, I'd like to invite our guest presenters to turn on their webcams. Greetings, Bryan, Cynthia. Thank you so much for joining us today. So I'll go ahead and I'll introduce Cynthia Clyburn. Cynthia Clyburn is a licensed social worker at Penn Neurology. Cynthia provides counseling, education, resource coordination, and psychotherapy to patients and families affected by a diagnosis of dementia. She facilitates support groups for patients with early memory loss and for caregivers of individuals with neurodegenerative conditions. Bryan Adler is a certified elder law attorney through the National Elder Law Foundation. He dedicates his practice to advising and counseling clients in the areas of elder law, life care planning, asset protection, veterans benefits, estate planning, guardianships, and long-term care advocacy. He's also a member of the Pennsylvania Association of Elder Law Attorneys and the Life Care Planning Law Firms Association. So welcome to you both. We're very glad to have you here with us.
We're glad to be here. Thank you.
Thank you for having us. I appreciate it.
Awesome. So let's jump into it. For some of our families who are currently going through the diagnostic process or newly diagnosed, I thought it would be a good idea, Cynthia, if you could start our conversation today talking about what are some of the challenges that people diagnosed with FTDs and their families may face in terms of legal, financial, and medical care planning.
Great, thank you. Well, so our families affected by FTD face a whole host of unique circumstances when it comes to legal, financial, and medical care planning. And in fact, just getting a diagnosis, they face a lot of challenges, right? So oftentimes we hear the story that someone begins to have symptoms of a behavior change. They go to their primary care physician. They may get bounced around to different specialists or told that they might have depression or they may need to seek counseling for their marriage, whatever it might be. So oftentimes we see a behavior change first, and people don't think that this younger individual or this person who is who seems cognitively quite well, physically well, could have FTD or could have a form of dementia. And so it's interesting that we're talking about financial care planning, legal care planning, because oftentimes that's the trigger for them to seek a neurological evaluation. Families will come to us and they'll say, I noticed that they had bought something that they would have never done in the past. You know, I noticed these behavior changes, but it was really when they bought a car without consulting me that I noticed that there was something wrong and we needed to seek further evaluation. So oftentimes by the time a family comes to us, there's already been some unusual decision making with the person who is affected by FTD. And whether it's impulsive changes in their care plan or impulsive medical care purchases, that's oftentimes some of the biggest red flags. So it's a huge priority for us to address legal, financial, and medical care planning right at the very beginning of a diagnosis. And in a perfect world, before a diagnosis, which doesn't often happen. So unfortunately, a lot of our patients don't have insight into the fact that they might be doing something unusual or having a change in behavior. So it makes it very challenging for families to react or to advocate for their loved one when their loved one doesn't always get on the same page with them about their advanced care needs.
Mm. Yeah, thank you for that. You brought up some interesting points about, persons with FTD sometimes experiencing having lack of insight. And Bryan, I kind of want to talk to you about that a little bit. Can you explain to us, when we think about lack of insight, the different levels of capacity and how that kind of relates to power of attorney, guardianship, or advanced directives?
Of course. So the commonly used phrase is capacity or cognitive capacity to make decisions for oneself. And the unfortunate reality is it's not math. It's not a science. It's more of an art. There are all manner of tests to assess someone's cognitive capacity, but when it really comes down to it, you could teeter on high to mid, mid to moderate, moderate to low. It all depends on the test you're taking, your particular educational background, your demographic background, time of day. Whether you've had a good meal or a good night's sleep can all affect how you might present on a cognitive capacity test. So the reality is that even though we need to assess capacity for a variety of legal reasons and financial reasons and clinical reasons, it's not always a perfect science. It really is a much more art. And you mentioned powers of attorney, you mentioned guardianship. I'll just throw out there as a blanket statement that the most critical legal documents anyone can have, but even more so those facing a neurological disease or a cognitive impairment, are powers of attorney. You need those documents to appoint someone else to make financial, personal, and medical decisions for you if you can't do it yourself. And the ability to sign those is based on cognitive capacity. So if you look at it as a scale, over here on my right hand is full capacity, the three of us. We're engaging in conversation. We know who we are, we know where we are, we know our family, we know our assets specifically. I mean, you can spout off where your bank accounts are, you can regurgitate what a power of attorney is, what it does, who you're choosing to be your agent to make those decisions, and why. That's the highest capacity standard, and that's where you need to be to sign a power of attorney. That's where you need to be to authorize or designate another person to make financial decisions for you. There's a reason for that. There's no framework to protect someone with a power of attorney. What that means is, if I'm my wife's agent under power of attorney and I walk into the bank and I steal all her money because I have access to her accounts, that's against the law, but there's no mechanism to stop me. The bank sees a valid power of attorney, they think it's fine, off I go with all the money. That's why they push the highest capacity possible on that. So you have to know exactly who you are, and what you're doing. If you slide down a little bit towards the middle, that's called testamentary capacity. That's the ability to articulate who your family is, about how much you're worth, and who you wish to leave your assets to, donative intent, who you want to leave everything to. That's a capacity to sign a will. And the reason for that is there are mechanisms in the law to protect people. If I leave everything, if I am coerced into leaving everything to Cynthia, she puts the thumb on the scale and says, Bryan, you sign here, and I leave her everything. Well, she raises probate. And she goes and takes my will and says, oh, Bryan left everything to me. By law, all my heirs have to be notified. My wife, my kids, all have to be notified that a will was submitted for probate, and they get to see it. So they'll see that Cynthia is taking all my money, and they can therefore challenge it. Then all the way down here at the bottom is the capacity, is zero capacity, no capacity. And that's the ability to sign a living will or an advanced directive, which we'll talk about later. It's murky where you have to be here to sign a healthcare power of attorney, but you can slide down a little bit more because there's so many built-in safeguards for healthcare powers of attorney. If Cynthia's my agent and we go to the hospital and Cynthia goes, hey, doc, amputate Bryan's leg, I'll just say, no, I'm good. Don't do it. Or the doctor goes, that's ridiculous. I'm not going to do that. You have these built-in safeguards. So that financial power of attorney, buying annuities, changing beneficiary designations, buying life insurance, selling real estate, that's the highest capacity necessary. And then you have that sliding scale going forward. If you're anywhere from here down, that's where you're looking at guardianship. If you don't have a power of attorney, financial or healthcare, and you don't have anyone to advocate for you, you might need to have a court appoint a guardian, which is a court-appointed agent under power of attorney. And I know, Dina, you're going to ask more questions about that in a bit, so we'll get into that in greater detail. But I want everybody on this call to take my lesson here, get a power of attorney. We'll talk about it in a moment, but you don't want to go for guardianship.
Good to know. Well, that's a great segue. Can you define for us and discuss the different types of power of attorney? And then also tell us, what an advanced directive is.
Sure. So there's really two basic powers of attorney that you need to have. One is financial, general, durable power of attorney. That's where, Cynthia, I'm going to pick on you the whole hour tonight. So you're going to be my everything. So Cynthia's going to be my agent under power of attorney. I'm going to sign this 20-page document, and I'm going to name Cynthia as my agent. I'm giving her the blanket authority to objectively do everything I can do. Anytime you would call someone and say, I'm Bryan Adler, Cynthia can do it on my behalf. Anytime I would sign my name, buy things, sell things, move money around, access my accounts, anything she can do on my behalf with one exception. She cannot sign a will. You can't rewrite my estate plan. But what Cynthia could do, which again lends itself to the power of a power of attorney, she can make herself beneficiary on all my accounts. She can make herself joint owner. So she could rewrite my estate plan. That's why it's so important to have this, because you need someone you trust. So that's financial and personal decisions. You've got a healthcare power of attorney. That's for medical decisions. That's for if I can't decide I want a flu shot, or I need to be admitted for surgery, or I need to go to a nursing home or assisted living, or if you need home care or health care or any manner of medical decisions. And it's also to waive HIPAA privacy. Cynthia can call my doctor and say, hey, it's Cynthia, I'm Bryan's agent. What's going on with him? What are the test results? I need help here. What did he talk to you about? She's allowed to do that. Mm-hmm. And typically inside that document is also a living will, also referred to as an advanced directive or healthcare proxy. That's my statement of end of life wishes. So if I'm brain dead, and that's very important, if I'm brain dead in a persistent vegetative state, 2 physicians are certifying that no matter what they do, the only way to keep me alive is artificially, then this is a statement of my wishes for Cynthia to carry out. Do I want artificial hydration? Yes or no? Artificial nutrition? Yes or no? Respiration? Yes or no? Pain relief, chemotherapy, blood transfusions. And the difference between a power of attorney and a living will, a power of attorney, I'm authorizing Cynthia to act. I'm saying make decisions for me, whatever they might be. An advanced directive is a statement of my wishes. I'm telling Cynthia, be my mouthpiece because I can't speak for myself. Carry out these wishes. I'm not giving you an authority to make a decision. I'm telling you what the decision is. I just need you to see that it was carried out.
Wow, thank you for that. That was really clarifying. So my question is, family goes and gets, a power of attorney implemented and completed. How do they use these documents? Let's say, for instance, a scenario, a loved one has power of attorney for their husband who may have FTD. Do they have the authority to override their poor financial decision-making choices?
No, not necessarily. So I'm going to use an example. I'm dealing with a family right now. Husband and wife. Husband has been diagnosed with dementia, and he was making very poor financial decisions. A lot of credit card debt, a lot of money to like those 1-900 charity type things, the scams, a lot of money on scams. And family comes to me and said, what do we do? And I said, you can't stop him because he presents so well. And Cynthia, you touched on this with your opening remarks, that FTD and many cognitive impairment, many types of cognitive impairment, people present well. They rise to the occasion. And they call the bank and they say, I no longer wish this person to be my power of attorney. I think someone's stealing my money. So there is really no way to lock it down. So with a power of attorney is a great way to access funds and make decisions for somebody if they need it. But you might need other interventions to save someone from themselves, to protect them from themselves. Could be asset restructuring, meaning you start to slowly move money out of the name of the impaired individual so they have less access. Reduce, maybe using prepaid credit cards or debit cards instead of credit cards. maybe leaving a few $1,000s in a checking account and moving all the rest to the name of the healthy spouse or the children or some other trusted individual. You can use trusts. You can use all manner of legal vehicles to protect someone from themselves. But that's a murky situation. It's very specific because you have to look at the dynamics of the family. And I see Cynthia nodding in agreement. She deals with this all the time.
Yes, yeah, I do.
So here's another question too then. If, I know some of our families are just getting diagnoses for their loved one who have FTD. Is it too late now at this point to get power of attorney, or?
No, it's I will say it can be too late, meaning you never say it's never too late, but never ever rush off to guardianship. The first step is I need a power of attorney, assess my loved one to see if he or she can sign a POA. And we talked about the capacity scale. There's gray area. I'm married with 2 children. If my wife comes into the lawyer's office and says, hey, I need to be the power of attorney for my husband, and my 2 daughters here with me want to be the backup. They're 4 and 6. It's a terrible decision, but my wife isn't known for her good decisions. Just kidding. She's probably on this. I'm going to hear about this tonight. But all joking aside, that's pretty typical. That's right. That's pretty typical. That's a wife for a husband and then the 2 kids. You can slide that capacity scale down somewhat. But Cynthia brings me into a lawyer's office and says, this is my buddy, Bryan. I want a new power of attorney appointing Cynthia. And Cynthia says he doesn't want his wife or his kids anymore. He wants me to be his agent. I wouldn't even touch it. I would say you can go somewhere else. Because it's so inherent. There's something so inherently wrong about that you have to push the capacity scale higher. So it doesn't matter to me where this person is on the scale. Let's have the conversation first, then we'll figure out what the appropriate solution is.
And Cynthia, in working with our families and our FTD community, can you talk a little bit to the value of having the power of attorney and advance directive, especially like during this pandemic phase, as Bryan mentioned before, where a lot of our families and community become susceptible to scams or having to make decisions about hospitalization and some of those medical decisions there?
Sure. This has actually been a catalyst for us to talk about advance directive. So having somebody having this pandemic and knowing that there could be some consequences where you could end up in the ER or having to make or being unable to make a decision for your health care or to advocate for yourself has been a way for us to talk about advanced care directives, although we should always be bringing up the conversation. But if you go into the hospital and you're unable to advocate for yourself, who is your power of attorney? Who's your healthcare proxy? Who's your agent that can call on your behalf and either be, quote, your mouthpiece or be the person making those decisions on your behalf? So it's very important right now at this point to talk about power of attorney, especially with the pandemic. Also, the isolation that has been a side effect of this pandemic. We've seen a lot of folks, I hate to say it, but we've seen a lot of decline because the systems that we depend on for care for our loved ones, whether it's structure or other folks coming in to visit and checking in on you, we have failed because we have to socially distance ourselves. And so we're seeing some cognitive decline, we're seeing some decline in function. So we are getting reports of unusual spending or unusual decisions, not being able to manage their care at home, and maybe folks that were living relatively independently before, now it seems that the pandemic has sped up a progression for folks, or again, they're not having that those supports to lean on that they normally do. So it's important to be able to have folks that you have identified that you can depend on, and already before this have a plan for your long-term care, have a plan for someone to help monitor your finances, your spending. So I think the pandemic has just highlighted just how necessary it is to have these documents in place.
And Cynthia, that's a really good point. Just to dovetail on that, I used this analogy earlier with a family that said they should have called our office 2 or 3 years ago. And I said, well, unfortunately, most people call the fire department when they see flame. You really should call when you see smoke, or maybe just have someone come out there and check the smoke detectors. Mm-hmm. You want to have all this in place well before it's needed, not just the documents, but where are the bank accounts? How much is in there? Get yourself recorded as a power of attorney, put on there so it's you have easy access to funds. Have the discussion. A living will is only as good as the person behind it understanding what the rationale is. You know, I don't care what the living will says. I care that my kids know what my wishes are so they can carry it out without having to read that.
Yeah. And another thing, just to piggyback off of what you just said, it's not just empowering the patient themselves to organize this, but it's also, you know, it's their right to self-determination, but it's also preventing their loved ones from having to make such a tough decision. So we're seeing what's happening in the news, and we're seeing that there are loved ones that can't visit and can't advocate for their family members in the hospital, and so making sure that you have something written out what you would want your wishes, your medical treatment to be, is so important, and takes some of that pressure off, say, your kids, or spouse's shoulders. Very well said.
And do these documents have to be updated, or do you recommend they be updated?
Yeah, so I do. The law changes with some frequency. There were major updates in Pennsylvania in 2009, again in 2015. Now, documents are almost always grandfathered in. So if your documents are older and you can't get new ones, okay, that's fine. The right advocacy will make them usable. But I always recommend a 3 to 5 year review, or if there's a major life change, marriage, death, birth, retirement, divorce, anything like that. What was that?
Diagnosis.
Exactly, a diagnosis of anything. You want to review something. You want to review it, make sure it's appropriate for what you need. But generally, every 3 to 5 years, you want to get those looked at, just to make sure. And it's complimentary. You know, most firms that any attorney that does documents will review them as a courtesy. Certainly know I will, and say, yes, you need an update, or no, you don't. Even if I haven't done the documents, I'll just do it as a courtesy to say, look, I'll look at these, and if you need the help, I'm happy. But if you don't need it, off you go. Call me in a few years.
Right. And Cynthia, talk to us a little bit about the infamous gray area and what we can do about it.
Yeah, so the gray area is something that we've kind of already touched on, but it's very unique to this population, especially the fact that they're so young and they are they present so well in so many different aspects, right? Physically, cognitively, but they have impaired judgment. And so it's really, I don't have a clear answer to what you can do about it. It's a collaborative approach. It's a customized approach, individualized approach to how you handle these situations. So I would say again, we're trying to be as proactive as possible, and speaking with either an elder law attorney, which would be a wonderful resource. Also, making sure that you have established a medical team, those that you can really count on. So not just your new neurologist that you've been seeing, but who's your primary care physician? Do you have a long-standing relationship with them? Can they vouch for your spouse or your appointed power of attorney being someone that you can depend on, that they have your best interests at heart? So making sure that you have a good history with these folks, and we try our best when there are concerns. And we hope that there is some sort of an intervention that can be made to help manage either their finances or their medical care going into a facility, or utilizing home care, whatever it might be. And if the person themselves lacks insight to know that there's an issue, we try to advocate that write either a letter of that this is this person's advocate. They have this cognitive impairment and they may need some support with decision making. We try to help them also that they can use however they wish, but we also try to help them prevent certain challenges from happening. So are there ways, and Bryan already mentioned like prepaid debit cards, are there ways that that your loved one with FTD can give you some access to their accounts so that you can have maybe even a view only of their bank accounts, and you guys know their shared assets, that you know their activity on social media and how they engage with, hopefully not scams, but how they engage with others in the community. Can you make those group activities so that you're trying your best to prevent as many risk factors as possible for financial scams, for making unusual medical decisions, so that it's a process in which everybody is informed.
Yeah, that's a great way to empower our families and persons living with FTD to be really proactive about planning ahead in their decision making. Are there any particular resources and tips you would tell our people in our FTD community interested in planning ahead with these kind of legal documents?
Yeah, so of course I would recommend an elder law attorney, and the Rothkoff Group is wonderful. But you can also, there's a search tool for the National Academy of Elder Law Attorneys that you can find local elder law attorneys to consult with. But there's also, there's a growing movement to have advanced care directives done in your own home, to research your own, research what options are available. There's the Our 5 Wishes document. Penn actually, in a lot of hospital systems now, have their own advanced directives that you can fill out and upload into your patient portal. We have one called Our Care Wishes, which is, it's pretty much the 5 Wishes document. And it can be uploaded into their chart, so they can appoint a healthcare proxy on there. They can write out their wishes for how they'd want to be treated if they were unable, if they needed life support or whatever it might be. So there's options for that nowadays, and there's lots of resources. I encourage patients to look at the AFTD so that you can make yourself familiar with what are the things you need to obtain, what are some resources there. There's also there's a growing field of death doulas. I know we've all heard of birth doulas.
It's really cool. It's fantastic. Yeah. I have a friend of mine who's one of them. I'm excited you're talking about this.
Yeah, I think it's a great field. We're all going to die. And it is something that you can utilize at any point in time, regardless of a diagnosis, where we talk about what is a good death, this right to self-determination, or taking this approach of, I want to be in control. I don't want to have my family members in control of this. And again, especially around the conversation of COVID and how we're dealing with emergencies with the pandemic, there are death doulas that can help you facilitate those conversations and recognize your own wishes, and then work with your family so that everybody's on the same page too. So they work with hospice and palliative care companies, but they also, you can utilize them at any point, whether you have a diagnosis or not. If you do have a diagnosis, you can also, at any point in your care, you can reach out to palliative care, to your local palliative care organizations, whether it's something covered by Medicare or a hospice organization. You can actually utilize that at any point in your diagnosis. A lot of people think that you can only utilize hospice care or palliative care when you're at end of life, but a lot of people reach out to them just for some additional resources, and they have social workers, they have nurses that can help you talk through through healthcare power of attorney. They can help you talk through advanced care directives. So if you don't have access to an elder law attorney, there are some other resources, at least for gaining knowledge and gaining an understanding of how you'd like to organize your wishes and who you'd like to rely on for support. But ideally, it would be to prior to diagnosis or right at a diagnosis, you speak with an elder law attorney.
Well, there's also, Cynthia, there's a good form, the PULSE form as well, I think is a really important document. So there's Pennsylvania, we're fortunate to have what's called a physician's order for life-sustaining treatment. And that whereas a living will is simply, it's an end of life declaration. A PULSE form is far long, I don't think longer is the right word. It's more comprehensive. When someone's been diagnosed with an arguably terminal illness, they can meet with their physician and go over and put together a very detailed care plan. It's pink, right, Cynthia? Yeah, it's a pink form that follows the individual along the care continuum, and it really details all manner of care options, as opposed to hydration, respiration, nutrition, and pain management. It's much more detailed and comprehensive, and it never hurts to ask. Whether you have a terminal condition or not, say to your physician, is it appropriate to do this? Social worker, case manager, whomever, and if it is, do it.
Yeah, awesome. I agree. So what actions would you guys recommend to caregivers whose partners who have FTD, of course, who refuse to see attorneys or to complete power of attorney and wills and advanced directives? What actions would you recommend for them?
Cynthia, you want to take that one first?
Yeah, it's certainly a common issue. And I think one of the points that we've talked about today is we would love to avoid the process of guardianship if at all possible. It's really, really challenging. It can be chaotic and heart-wrenching, really. But it's easier said than done. Again, I try to take an approach, and again, especially with the pandemic, but an approach of this is you in control of your healthcare decision making, because a lot of times their behaviors might, their defensiveness or their reluctance might be stemming from not just their FTD symptoms, but stemming from this feeling of lack of control over what's going on. I'm trying to hold on to control as much as possible. So can we change the narrative so that, again, this is empowering the person to make that decision? Can you incorporate into this conversation other people that they trust? Sometimes we get some unusual fixations on the caregiver. We might develop some delusions or a storyline of they're trying to take my money or whatever it might be that might not often be accurate to what the person is perceiving. So can you include other trusted members like their doctor, again, having a long-standing relationship with that doctor, primary care physician, a neurologist, a social worker to help you facilitate the conversation between the family, and hopefully getting that person on board. Can you also, tap into other community resources? So there are dementia-friendly banks. Do we have an understanding of exactly what is happening here? If there are problems with money management, or if there are some unusual social media activity, emails, scams, whatever it might be, have they been calling the doctor and requesting unusual things? If you can try to observe those things as well, so you can gain a full understanding of what challenges you're facing, and try to report that to your doctor if possible in the doctor's visits, if you're also in attendance, and having, again, those conversations with people that they trust, switching the narrative so that it is more empowering, as opposed to we need to take this this responsibility away from you.
That's right. It's about choice. They're already losing so much. People are suffering so badly already. If you can put the choice in their hand, that's the best way to do it. And I look at myself and my partner and I and our entire team. We are lawyers, and yes, we're a law firm, but we look at ourselves more as healthcare advocates. And in that regard, as Cynthia knows and Dina, you know, we have social workers on staff, we have care coordinators on staff, and our team, I spend as much time immersed in healthcare advocacy as I do in legal advocacy. So over the course of a career, you just learn how to relate to someone, you learn how to talk to them, you learn how to talk to them on their level and not get down to their level, because it's not the right phrasing. It's talk to them on their level, identify what they're worried about, and you persuade because you know it's in their best interest. You don't necessarily have to involve someone who is cognitively impaired. You know, we hear from families all the time, oh, I got to talk to my mom about this first. Well, mom has severe dementia or even moderate dementia and can't comprehend this. We need to find other interventions here. We have to find a way around this in mom's best interest. So as much as it is important to include the person in there, you also have to look at what the end game is, what the practicalities behind it as well, to make sure it's a fruitful effort and not just running in circles.
A lot of times, family dynamics play a huge part in how a lot of these situations play out. So when there are situations when these documents are not completed or enacted, who gets to make these decisions for the person who has FTD? Is it, you know, the spouse or children or siblings? I know this really comes.
Who gets to? It's
Yeah.
it depends on who wants to. So when it comes down to it, there's a healthcare statute in Pennsylvania that theoretically allows for a parent, a spouse, children, grandchildren, nieces, nephews, siblings to make decisions in a specific order on the healthcare side. But the reality is, and Cynthia's in the medical community, she can attest to this. I make a phone call to Cynthia and say, hey, I'm my dad's son. I want to know all the information possible, and I want to talk to you about his care. She's going to say, go pound sand. And say, show me a document. I mean, Cynthia might talk to me a little bit, but the reality is, without that piece of paper, she's not going to say, oh, really? According to 53 PACS 5201, I can talk to him. Of course I can. It doesn't work like that. So there is a statute that theoretically does the job, but I wouldn't rely on it. And if you don't have those powers of attorney, there's no mechanism. There is no, I'm the spouse, give me access to the bank account. There is no, I'm the spouse, I'm going to call Medicare and ask about coverage. You need to have that document, or you're going to traipse off to court and have to get a judge to appoint a surrogate decision maker.
Interesting.
Yeah, and also we're fortunate enough that a lot of times people do come to their doctor's visits with an informant, so with an adult child or with a spouse. So and there we do get permission to speak with that family member, and so that's great for us. But you know, one of the challenges I'm thinking about us from a neurological perspective from our office, but think about the folks that go without a diagnosis, that you know, their primary care physician or they haven't received a diagnosis of FTD. So appointing someone to talk to when there's not even a diagnosis of a dementia form of impairment on their chart. I mean, I just think about COVID and about people making decisions and going into into the hospital and not having anybody that they can speak with, or having folks that have challenges, you know, calling in and getting information about their care. It can be. It's
Cynthia, you said that, you articulated that perfectly. I mean, right now with COVID, you can't just walk into a hospital, nursing home, assisted living, anything, and advocate. And it's a lot different. My father went in the hospital, and I walk in there and say, hi, I'm his son. And what's going on? I'm sitting at his bedside. There's a natural credibility to that, because people generally don't wander into hospitals, sit down in someone's room and start asking for information. You pick up the phone and you start asking questions about things. Sure, there still might be some credibility there, but just isn't the same as being bedside. So without those protections, and no one had the foresight to think they're going to get this infection and be taken down in a matter of days and possibly on a ventilator for months. Whether you have dementia, cognitive impairment or not, you'd never expect to be taken down by a buzzsaw like COVID is. And if without that planning, you might find yourself up a creek. I had to temper my language there.
Yeah, well, I know there's a lot of people tuning in today that really want to dive into guardianship, and especially since we know persons in our communities suffer from symptoms like lack of insight or agnosia, compulsive behaviors, and deficits with executive functioning. So, can you tell us how we can identify when and why more legal assistance around guardianship may be needed, and how do we do it? Like, how do we get it?
So guardianship is legally referred to as the least favored method of exercising influence and control over another's person, meaning their medical decisions, or estate, their financial decisions. It's a literal last resort. So the unfortunate reality is, though, we're in court dozens of times a year seeking a formal guardianship because there was lack of planning. So while I'm encouraging everyone out there to avoid it if you can, the reality is you might not be able to. So families come to us and they say, my dad is in the hospital. He needs long-term care, whether it's nursing home or assisted living, memory care. We have no powers of attorney in place. And my first question is, okay, let's talk about his cognitive capacity. And they tell me he doesn't know where he is, what the date is. He doesn't know who we are. He is confused and agitated. I'm hitting all the high points. I'm saying this person is objectively impaired. I say, okay, we don't have the capacity to sign a power of attorney. So you have to file a petition in the orphans court of the county in which the individual resides. And it outlines clinical background. What's going on? Who's his family? What's the diagnosis? What is the relief that we're requesting in the form of guardianship? Why do we need it? And I need to get a doctor. I need to get a doctor who knows this individual, ideally a psychologist, psychiatrist, neurologist, who not only knows the patient, but also understands dementia and related diseases. To articulate in writing, it's called interrogatories or deposition, to say why this person needs a guardian, that they can't make safe decisions for themselves. They don't understand information. They can't articulate a choice, and their condition is likely to either remain or deteriorate. And we file it, and you wait, sometimes 60 to 90 days, and you have a hearing. And we all go downtown, and the individual may have to be there. The alleged incapacitated person may have to appear. The alleged incapacitated person may have an attorney appointed by the court. I go, the proposed guardian goes. All the kids have to consent, or the spouse has to consent to this individual being the guardian, or they have to show up and say why they object to it. Have a hearing, and the proposed guardian testifies. The alleged incapacitated person may have to testify, depends on circumstances. And the judge asks all kinds of questions. It could take 2 minutes, it could take a day. I've had all manner on the spectrum. And then if we are successful, the judge says, great, here's your guardianship paperwork. And now we're off to the races. That means you can make personal medical decisions, residential decisions, but you cannot spend the person's money. You can only spend their income, meaning the money that comes in every month. You have to request leave of court. You have to go to the court and say you need an allowance to spend money in excess of income. For example, we go to a memory care community, and that's where we're going to reside. That's going to be $6,000, $7,000, $8,000, $10,000 a month potentially. Well, that's often more than most people's income. So we got to go to court and say, Your Honor, we need an allowance. I need your permission to spend money on these expenses. We need to sell a house to pay for care. Your Honor, we want to sell the house. And the judge has to approve it, but there's all these things that have to happen before that. So while it's a very good option because it exists, it's more restricted than a power of attorney, particularly when it comes to a healthy spouse. There's all manner of asset protection that we engage to protect a healthy spouse's financial safety while preserving the incapacitated spouse's physical and social safety. A guardianship makes it more difficult, but I want all of you out there that think it's too late. It may be too late to get a power of attorney, and that's okay. You didn't do anything wrong because you didn't know any different. We can still seek guardianship. You can still protect yourself and your loved ones very well. just a little bit more difficult.
Mm.
That's what I'm here for. That's why we exist. We're here to make it easy for you. I say more difficult. My whole job is to not sleep at night so that the families I work with can go back to sleeping at night.
Nice. And Cynthia, can you talk to us a little bit about how the medical team is involved in the process? Like, what role do they play in helping support these families through this?
Well, a lot of times people, family members need some validation of the symptoms. Yes, we are seeing the same thing that you are seeing. This is how they scored on this cognitive evaluation. You know, based on your story, and based on the lab testing, the imaging that we have received, we can see that, you know, although we're not with you day to day, we can see that there is an impairment, and there's an impairment to their judgment, insight, whatever it might be. So one, helping the emotional validation. This is what's happening. You don't have to question yourself if this is the right thing to do to pursue power of attorney or whatever it might be. Two would be you can work with your medical providers, whether again it's a psychologist, psychiatrist, neurologist, long-standing relationship with your primary care physician to advocate for their capacity. Sometimes, like he said, with guardianship, they may need some medical office visit notes, whatever it might be, a history, or a physician to advocate that that they do have some level of incapacity, that they have a cognitive impairment, and you know, this is the what's affecting their judgment and why they need this advocacy. They need a decision maker. So your doctor, a social worker may be able to help you talk about when is the right time to seek that medical clinical information to support that case. Going back to the guardianship, I do always tell families just how chaotic it can be, even though, yes, you can have a lawyer walk you through it and everything, but if you can avoid it, that would be wonderful, just because them having to present in court, it can get really messy, and it can cause quite a rift in family dynamics, and it's really hurtful.
Well, let me tell you that Philadelphia City Hall, they air condition the courtrooms, but not the hallways. You go down there in August, be prepared to sweat.
There's another point.
Cynthia brings up a good point, though, that, you know, I think Cynthia works in the clinical environment, but there is a misconception that there's not real social support there. I mean, Cynthia and her team, they look at this from they don't look at this as a problem to solve. They look at it as a problem to also support, and an issue to support. And I think that's often overlooked, that there are tremendous social supports that Penn provides that take the fear away from it, that can help organize your thoughts. So whether you start with Cynthia or with an elder care attorney or with the association, someone's there to help you organize this pile of rocks into a path with what's most important on down the road.
Our job is to guide you and to support you, and you know, we can't necessarily, you know, make someone get power of attorney, but we can offer that support and that guidance, and just information. Knowledge is power, about what to do.
Absolutely. As does AFTD. We support a lot of our families too through our helpline too. We take tons of calls as well. So we do understand it's very much a journey, and families do need support, and we're happy to be able to help guide them through this process.
I do have one point on that same frame, and I would be remiss if I didn't say it. But not only is this an opportunity to empower the patient, the person diagnosed, affected by FTD, but it's also a time that you need to be speaking with the spouse or caregiver or whoever that person is, because a lot of times the spouse has their loved one with FTD as their power of attorney. So you need to make sure that you're addressing that as well. I see Bryan nodding.
Cynthia, that's a great point. I see it all the time. All the time. You have, and then you run that risk that it might be too late to change it.
Right. Well, we talked a little bit about guardianship, Bryan, but can you tell us, like, where does conservatorship kind of enter in this spectrum? Are they different?
So that's a common misconception, that there's a difference. So conservatorship in Pennsylvania, we use the phrase guardian of the person and of the estate, or both. So the estate is the finances, the income, paying bills, things like that. The person is medical decisions, residential decisions. And you don't always need both. You know, you might have a person who comes in and has a healthcare power of attorney, but they failed to do a financial power. So you need guardian of the estate. You might have somebody who has a great financial power, but no healthcare directive or healthcare power of attorney. You need guardian of the person. The term conservatorship in other jurisdictions like California, for example, you have guardian, which covers the person, and conservatorship covers the estate. So those of you who are familiar with Britney Spears, she is subject to a conservatorship still. I think it's been 20 years. She has, her father, I believe, is her conservator, but she still has her own control over her own personal decisions, just not her finances.
I was thinking that, but I was too embarrassed to bring up Britney Spears. So I'm glad.
Oh, I'm not. I follow. I mean, look, Us Weekly is on my dining room table.
Awesome. So what I'm going to do now, guys, thanks a lot. I'm going to take a look at a lot of the questions that are coming in. People have tons of questions that they want to ask. I'm going to field some for you. Bear with me just a second here. So I have a question that kind of came in, and these are all pretty nuanced. So let's take a look. So I guess this question should go to Bryan. So how detailed do power of attorney documents need to be? Should they list everything that an agent can do, or is it okay to have general permission just to make financial or medical decisions?
So Dina, are the majority of our participants tonight from Pennsylvania, New Jersey area, or is it all over the country?
They're all over.
Okay, so the answer is it should be as detailed as possible. Meaning, if you see one of those, if you have a one-page power of attorney, I will say certainly New Jersey and Pennsylvania, but I'll venture that the rest of the 48 states, you might as well throw it away. You need to have very comprehensive language in there, and particularly in the states in which I practice, there are certain authorities that are critical when it comes to cognitive impairment planning, dementia planning, Alzheimer's planning, long-term planning, that if the power of attorney does not include these provisions, they are presumptively excluded, such as transferring assets, beneficiary changes, accessing certain accounts. You want it to be as comprehensive as possible. And you need to realize that the power of attorney I prepare for Dina or Cynthia is going to look different than what I prepare for Dina or Cynthia 50 years from now when they have a cognitive impairment. So there are elder law powers of attorney, there are younger individual powers of attorney. It all depends on circumstances. Very detailed, the better.
Awesome. Thank you, Bryan. And can you speak a little bit to that power of attorney, like the first and second agent? Is there a difference between the first and second one versus what they can do, or why it's important to have a first versus second one?
So I always recommend you appoint a primary and a successor, if not two successors. The primary agent is the one that serves, period, until that primary agent dies or resigns or is revoked, was removed. Then the successor agent steps in. So you always want to have a backup or two backups because you never know. If you are 75, 80 years old and your spouse is your agent, there's a good chance your spouse might predecease you. So you want to have that backup, ideally somebody who is, a child, somebody who's younger than you. A sibling is certainly fine, but you still run the same risk. You can also have co-agents, meaning you can have a spouse and an adult child serve together. The benefit of that is when you record that, when you file that power of attorney, you're getting both those people on. So even if dad's doing all the work, if God forbid something happens to him, daughter or son can step right in. You don't have to go through all this process of refiling the POA, going through all these formalities the banks will always impose upon you. You step right in and start making decisions.
Awesome. Let's say hypothetically, I have durable power of attorney for my husband, and my adult son decides that he's going to now be the caregiver for him and moves him to a totally different state than where I live. Would I still be able to enforce all of my decision-making capacity with my durable power of
Yes.
attorney?
So the short answer is yes. The Full Faith and Credit Act of the United States of the Constitution supports a power of attorney that's proper in the jurisdiction in which I resided when I executed it, should carry over to the state or jurisdiction to which I move. However, if you have the ability to revise them, do it. Because banks are pains in the tush. For those of you out there that work at banks, I apologize, but they're pains in the tush. They're reluctant to accept a power of attorney. There's a lot of hoops you have to jump through. And the form that a Pennsylvania POA takes can be a lot different than the form a New Jersey one takes, California, New York, they're all different. So while they'll be accepted, most likely without a huge problem, you're just gonna have to jump through some hoops. If you can update it, do it.
And I know, Cynthia, you had mentioned the dementia-friendly banks, and we were just talking about banking. What do we do to get access to families' accounts when you have the power of attorney, you have the note from the clinician, and banks are still giving us a hard way to go?
Well, I would say if you have a note from your physician, you should present that. You should also, and again, your power of attorney paperwork. But I would speak with management. I would speak with folks about their dementia-friendly protocols. Talk a little bit more with folks that maybe aren't presenting so many barriers to, how do we enforce this? How do we utilize this? Can I speak with a manager about this? And keep asking, because if you've presented these documents, then hopefully, and there's some wiggle room for them to work with you. I fear that, we've talked a lot today about legally these provisions that you need to have, all of these documents that you should have in place, and being as proactive as possible. But for some people, that's just not something that they've done, and they still want to avoid guardianship. Some people have barriers to being able to afford a great lawyer, and they can seek as much support as they can from free legal clinics, but sometimes it doesn't get them that far. I do just want to make the point that it's not hopeless, that there are still people that you can consult with, you can ask for help. Even when my folks are trying to navigate getting into, say, a memory care facility or a skilled nursing facility, there's people at admissions that can say, oh yes, we have been through this story before. So let me tell you how we normally work with families on this, or how we normally get the person with FTD to recognize that this would be beneficial, or this is the way to go. So there's always helpers. Look for the helpers, right?
That's right. Look for the interventions, look for alternatives, because even if you don't have power of attorney, you don't have a guardianship, there is a middle ground that you might not need either. There's a reality that exists where you just might not need it.
So I know, Bryan, having one child as the medical power of attorney and the other as the financial is usually kind of frowned upon. Is there any situations where this could be helpful?
No, I don't think it's frowned upon. I think it's fine. I don't object to that. I think that sometimes there are siblings and children that are better suited to make medical decisions than others are better to make financial decisions. The reality is that sometimes the more emotional, more sensitive child is the worst person to choose for the medical decisions or end of life decisions, because it's a difficult decision to make. Sometimes you want that person, the emotive person, to be the one in charge of that. You might have a child who's great with money, but is lazy or stupid. Well, stupid's not the right word, because if they're good with money, they're probably not stupid. Lazy, or isn't involved, or lives far away. Pick whoever is best for the job, regardless of the relationship to you. You want to trust them. I'm working with a family now, and dad said, well, I want my children to be my agents under power of attorney in age order. I said, why? So I think it's the right thing to do. His oldest son, bankrupt, relies on dad for money, is a ne'er-do-well, is constantly siphoning. I was like, this is a bad idea. This is why I don't want to hurt his feelings. So that's a bad move. That's bad. It's a bad choice, because you don't want to hurt his feelings. That's no matter to me. You got to pick somebody you know is going to do the right thing.
I also agree with that. And I also think dividing up the tasks or the different roles. Everybody wants a role to play. They want something that they can physically assist with, whether, or, you know, it's such a feeling of helplessness with these diagnoses, right? Because there's a lot of uncertainty. There's a lot of unknown about, you know, the progression, when you'll need help, and what kind of help you will need, those sorts of things. So people want to be able to help. And if you have folks that you're looking at it from a strengths-based perspective, where, you know, again, this person's great with finances, and this person I think would make the most sound decisions, and this is a family conversation that you can have. I think that's an empowering conversation. I think that's dividing up those roles is really helpful.
And Cynthia, to that point, the discussion is the most important part. Put everyone around the table. You know, you don't just, again, not to use too many experiences, but I met with a family earlier, and we're doing this planning that involves transferring assets to one particular individual for a very specific reason. And I said, we're not going to do this unless all the kids are around the table and they understand why we're doing this and why it is truly for mom's benefit. Because if they don't understand, it could look like it's the wrong choice. Get everyone around the table, have the discussion, make sure they understand and are all on the same page, because ultimately it's about communication.
Yeah. And about feeling, everybody on the same page, but feeling included also in someone's care. I can say as a person who lives in a different state from my family, all my family is in South Carolina, I would want to have some sort of a role and be in agreement and feel included in my mother's care if she needed support. Even though my brother lives just a couple miles down the road, you know, if I could continue to have a role in her care, even though there's 1,000 miles between us, you know.
Cynthia, I thought I caught like just the slightest Southern lilt to your voice. It's just almost imperceptible.
One y'all, and then the rest is.
That's great.
So Bryan, does something special need to happen for families to start using a power of attorney? How do they get it activated?
First, you have to sprinkle the magic power of attorney dust. It's a matter of taking it to the bank and saying, I'm the power of attorney for my loved one, and I'd like to put this on file. Okay. That's the crisis way to do it. That's when, you know, it's been sitting in a drawer and you need to use it all of a sudden. The better way to go about it is when you sign it, meaning when I signed my powers of attorney, I went to all the banks and I said, here's my power of attorney. This is my wife. Get what information you need from her, and I want to put her as POA on all of my accounts. And it's done. That's how I recommend doing it. Once you have it signed and you are comfortable with your agent, go put them on all the banks. And some banks, if you, the individual, some financial institutions, if you, the individual, go in, you don't even need to present the actual POA. You can just say, this is my wife, here's her social security number, her birth date, and I want this person to be my agent, and they just put it right on the file. They don't need to actually see the document because I'm making the decision myself.
Fair enough, fair enough. Now here's a tough one. So if a family member decides, you know, they have FTD and they decide, hey, I want to revoke my power of attorney or live in trust, is there a legal or ethical responsibility for the attorney to provide notice to the POA agent or the trustee?
Yeah, there is. So if the principal wants to revoke a power of attorney, you need to do, that's a formal revocation. You got to notify the agent, and you have to notify all the banks that it might be on file with. You know, if you go and put this in at 5 institutions and all of a sudden it gets revoked, well, those institutions have to be notified of the revocation. So that's issue number one. But the larger issue there, Dina, is that person have capacity to revoke the power of attorney. That's where things can get murky and very ugly.
Right.
And again, with FTD, with that presentation, they might seem like they have more capacity than they actually do. So
that's right. It's one of those things where it's a bridge you cross when you get there, and the only answer is you got to figure it out. You know, we have families that say, well, what if this happens? You can have 20 families the exact same thing happen. It's 20 different solutions because it all depends on so many variables. Just figure it out.
Now, during this time, during COVID, it may be really hard for people to get out of the house, to meet with attorneys. is it acceptable to do alternatives to making power of attorneys? Like, should they go online, or should they do like Quick and Will Maker? Like,
okay, so I'm going to address that real quick.
Okay.
So our practice is entirely virtual now with very limited exception, and it hasn't been a problem at all. We do most of our meetings with limited exception over Zoom or GoToMeeting, document signings, all of that's no problem. I look at LegalZoom and all of that. You want to take a swing at it, rock on. It's not that much less expensive than an attorney. I've gone through this myself because I want to see what it was all about. It's not that much less expensive. And the way I liken this is there's two issues. One, it's like buying furniture at IKEA. You're going to put it together yourself. Inevitably, you're not going to quite know if this piece fits to that piece. It will probably look okay, but you don't know, and you can't be sure that when you have to rely on it, it's not going to fall apart. But then the document that's just the first step. Then what? What if the bank refuses to accept it? What if the law changes? What if you choose the wrong agent? How do you advocate as an agent under power of attorney? How do you make decisions? What's the standard that you are subject to by the law as a surrogate decision maker? You go to LegalZoom, it's 10 pieces of paper. That's it. It's worth whatever those 10 pieces of paper are. It's then what?
Right.
I just to address that, and I agree. But I also have two frames of thought on this. One, if you're going to do something, do it right. Yeah. So make sure that you have properly vetted folks that are helping you, elder law attorneys. But there's at the same time, it's better to have something rather than nothing.
You're absolutely right.
So on the flipping the coin there, but
she's right.
But so look at things that you can do. So if people have barriers like income, being able to afford even LegalZoom. So if you can reach out to the Senior Law Project, if you can reach out to, which is in Pennsylvania, we have an advocacy group, legal advocacy group. Most counties have a free legal clinic and some assistance. So if you can reach out to those resources and gain some insight into what you can do. Also, looking at the National Hospice and Palliative Care, I think Foundation or Association, I can't remember, but there's a search tool that lets you look into, at least for your advanced care directives, what is recognized in your state. So you can type in your zip code or your state, and they will tell you what advanced care directives are accepted, and you can even draw something up online with that if you'd like, and have at least your living will or have an advanced care directive set up.
And you touched on the 5 wishes, which is that there's no charge for 5 wishes. It's a perfect example.
Yeah, and actually there's a dementia-friendly one as well, and a lot of our patients with Alzheimer's disease utilize that one. And then PEN, just to plug PENs again, but ours is called Our Care Wishes. It's pretty much 5 wishes. It's exactly the same.
I love how you're whispering it like the 250 people on the call can't hear you.
But it uploads right into the chart, and so that's a great thing that you can do, something rather than nothing, right?
Cynthia, you're absolutely right. Community Legal Services VIP Senior Law Project, great option because it covers the then what. I'm talking LegalZoom and Rocket Lawyer and things like that. That's where I have a real problem because no one knows what to do with it. And also, I want to point out, I have furniture from IKEA, so I'm not anti-IKEA. I just generally have pieces left over and it falls apart.
So Bryan, one last question. If capacity needs to be addressed or determined for a legal reason, like to obtain a GAL for a divorce, can that capacity determination be used for additional petitions for guardianship after divorce proceedings have been completed?
Possibly. Depends on what the statement is in the capacity determination. For example, a lot of people have in their medical file, the doctor notes, the physician notes, this person lacks capacity to make personal decisions. That's not going to cut it for a formal action. You're going to need a true physician's deposition that outlines what's going on, details the condition, that it's not likely to improve. So it's possible, just not a guarantee.
Awesome. Well, we're just about almost out of time. I want to give a big thank you again to both Bryan and Cynthia for
Thank
joining
you
us.
all.
At this point, I'd like to ask if we could turn our webcams off so we can go ahead and close out the presentation. So we hope you found this presentation to be informative and leave with new tools that you can use during these challenging times. We will post a recorded webinar on AFTD's website under news and events and send out the link as soon as it's available. If you have FTD in your life, we encourage you to turn to our website, theaftd.org, as a source for help and support. Our website is filled with resources to help you on your journey, including some that pertain specifically to the current pandemic. Access the COVID-19 and FTD section of our website under the Find Help menu on our homepage. Additionally, our helpline and private Facebook groups offer individual information and support. We're working with AFTD support group volunteers, many of whom have been able to offer virtual meetings for their existing groups amid the COVID-19 crisis. And lastly, before we sign off, we'd like you to know about an important upcoming event, World FTD Awareness Week. It is held each year by the coalition World FTD United to promote greater FTD understanding around the globe. This year, it runs from September 27th through October 4th. AFTD and our World FTD partners will be hosting virtual events throughout the world, most notably on Saturday, October 3rd. Presenters from around the globe will share information, helpful resources, and the latest updates on frontotemporal degeneration through a day-long program known as the 2020 World FTD Marathon. AFTD's annual Food for Thought fundraiser also begins September 27th, and that's an opportunity to raise FTD awareness and enjoy delicious food at the same time, while raising funds to support AFTD's mission. Information for that can be found on our website. Some of AFTD's volunteers have a special new FTD challenge planned. This challenge is designed to raise funds for our community and beyond, and to share stories from families affected by FTD. So we can't say much yet, so stay tuned about visiting our website by joining our mailing list and following us on social media. Please let us know if you have any comments or questions about today's presentation or about other ways AFTD can assist you moving forward. Thank you for joining us today. Until next time.